Thank you, Chair. I hope all of you can hear me and also see the presentation on the screen. So good, I hope that works. So thank you very much for inviting me and in fact my colleague Balázs, who is in the room today, to give you a brief presentation about our work in the area of law enforcement cooperation in the area of fighting foreign bribery under the OECD Anti-Bribery Convention. And again, I want to thank the Chair and the Competition Committee for inviting us. We'll just give a short presentation. If you have any questions, we're happy to answer them either during the presentation, as the Chair suggested, or shortly thereafter. So here is the overview of our presentation. I'll just start by giving a short presentation on the OECD Anti-Bribery Convention and the Working Group on Bribery, in case some of you are not completely familiar with our work. Then I'll jump into four of the main activities that we in the working group engage in the area of international law enforcement information exchange. So those are mutual legal assistance in criminal matters, jurisdictional consultation required under the convention, an activity known as the matrix and the tour de table, then the informal meeting of law enforcement officials. And then at the very end of the presentation, I'll just say a few words about the issue of data protection, which is an issue that has cropped up in our work because of our work on law enforcement information exchange that perhaps you should also be mindful of as you embark on this area of work. So I'll start with the presentation, and then my colleague Balázs will jump in later on. So first of all, as an overview to the Anti-Bribery Convention and the working group, the full name of the convention is the Convention on the Combating of Bribery of Foreign Public Officials in International Business Transactions. So as you can see, that's quite a mouthful. That's why we often just take a short form of the convention and just call it the Anti-Bribery Convention. Now, the convention, as the name suggests, does not deal with all types of corruption, but deals with only the bribery of foreign public officials in international business transactions, which is again a mouthful, which is why we often call it foreign bribery. The convention is a criminal law convention, and by that it means that the parties to the convention are required by the convention to make foreign bribery a crime. The convention itself entered into force in 1999. And up to now, we have 44 countries that are parties to the convention, so the 38 OECD member countries plus 6 non-members. The convention also says that the OECD Working Group on Bribery in International Business Transactions is essentially the conference of parties of the convention. And so the working group, for short, meets 4 times a year in Paris. And for each of those meetings, the meetings last usually about 4 days, where it discusses a range of issues, including some of the issues that I will talk about later on in the presentation. So the first area where the convention provides for international exchange of information for law enforcement officials is in Article 9.1 of the convention, which deals with mutual legal assistance in criminal matters. So I've reproduced the gist of Article 9.1 on the screen. It's quite straightforward. And in fact, it mirrors the language found in a lot of mutual legal assistance treaties. It just says the parties to the convention are obliged to provide prompt and effective legal assistance to another party to the fullest extent possible under its laws and relevant treaties and arrangements. In addition to 9.1, there's also Article 9.2, which provides that where the conduct underlying a request for assistance falls within the conduct of foreign bribery as defined in the convention, then automatically that request is deemed to meet the requirement of dual criminality. Article 9.3 of the convention also adds that bank secrecy is not a ground for denying mutual legal assistance under the convention. That is all the article says. It's quite a short article, and so for most of you who are familiar with the area of mutual legal assistance, you will notice that in fact this provision, Article 9, is not quite like a full mutual legal assistance treaty. It does not deal with details like the transmission channels for sending a request or the channel for receiving the evidence. It doesn't talk about mundane things like authentication of requests or other grounds of denial of assistance beyond bank secrecy and dual criminality. And on its face, in fact, the provision doesn't even, it quite obviously says it doesn't serve as a treaty because it refers to the country's others, laws and relevant treaties and arrangements. So it seems to be asking countries to rely on other instruments to provide mutual legal assistance. That said, many of the parties to the convention have stated on the record that they will in fact accept this provision, however bare and simple it is, as a treaty basis for sending and receiving mutual legal assistance. Okay. Then I'll move on to the second provision in the convention that deals with international exchange of information. That's Article 4.3. And I've reproduced the entire provision on the slide. And it says, where more than one party has jurisdiction over an alleged offense described in this convention, the parties involved shall, at the request of one of them, consult with a view to determine the most appropriate jurisdiction for prosecution. So it's quite a straightforward provision that just basically says, if there is a foreign bribery case where more than one country has jurisdiction over the case, then those parties to the convention are legally obliged to contact one another in order to coordinate and to consult and exchange information. So with that, I'll turn the floor over to my colleague, Balázs.
Yeah. Thank you, William. Article 12 of the convention establishes a monitoring framework, which is done by the Working Group on Bribery, formed by the parties to the convention, and it's a peer evaluation system supported by the Secretariat. I'm not going into the details of the monitoring because it's done in cycles, results in reports adopted by the Working Group on Bribery with a consensus -1 decision-making procedure, establishes also recommendations in the reports, but this is not the focus at this moment. It's not the most important part from our actual topic at hand. The Secretariat for the Working Group of Bribery maintains the matrix of foreign bribery cases. The matrix is a database, actually. The known foreign bribery cases by jurisdiction cross-matched. There is a reporting obligation for the parties to the convention, and a quarter of the member states report at each of the plenaries. So every member state has to report once a year on the cases, the development in the cases of the matrix. Of course, this once-a-year reporting may not seem to be a very up-to-date database. The result of it may not seem to be a very up-to-date database, but if you consider that a given case can be involve more jurisdictions around the table, on a given case, almost continuous information flow can be maintained in the Working Group on Bribery. Yeah. Also, this reporting opportunity and this reporting obligation at the plenary meetings gives the opportunity to the other jurisdictions involved in the same case to ask questions and give answers to each other. For example, about pending MLA requests they were exchanging before. Also, sometimes it's also a possibility for the members of the working group to realize that their jurisdiction is actually involved in a potential foreign bribery case. It also helps to connect investigations done by different jurisdictions in the active and the passive side of the bribery. Sometimes the links are established. There are actual case examples where the links were established based on the matrix reporting obligations. Of course, the result of these established links can be the establishing cooperation, informal or formal cooperation later on. The next level, the next slide, please. The next level of practical cooperation facilitated by the Working Group of Bribery and the Secretariat is the informal meeting of law enforcement officials. the OECD Council gave the Working Group on Bribery this mandate to establish a forum for law enforcement officials who are actually involved in foreign bribery investigations and prosecutions to be able to discuss issues connected to the topic. And the law enforcement officials informal meeting in the last 10 years have held twice a year, so not at every plenary meeting, but by next to 2 plenary meetings, and it is held in a confidential setting. The requirement of membership for the law enforcement official meeting is rather strict. There is some vetting done, making sure that the information exchanged in this setting are only given to those who are entitled to have that information. There are also thematic discussions in this informal meeting. The topics are usually exchanging experience, good practices, discussing legal or practical obstacles encountered by the authorities, law enforcement, investigators and prosecutors during their cases. From experience, international cooperation works on mutual trust and personal contacts. And the law enforcement informal meeting of the law enforcement officials is an excellent forum to establish those working relationships and informal and formal contacts. The membership is rather stable, so the same counterparts meet from time to time. And we have actual case examples where the cooperation has been indeed facilitated by these contacts and bilateral informal meetings on the margin of the LEO meeting. The combination of these 3 practical cooperation tools, by which I mean the matrix and the tour de table and the working group on bribery meetings and the LEO meeting, add a lot to the cooperation, a lot more than a simple statement in the convention that there is an obligation to cooperate. It may help to explain why the most successful foreign bribery cases were conducted with the involvement of the working group on bribery member states. Thank you. William?
Yes, so I'll just wrap up the presentation with just the last little bit on data protection. And the reason I want to bring this to your attention is because this is a topic that, because of our work on law enforcement information, it has led to a lot of subsidiary work arising because of data protection issues. So for those of you who may not know, data protection applies to personal data. The definition of personal data is information from which an individual is identified or is identifiable. Now, when we work with law enforcement actions, prosecutions and investigations and so on, that information necessarily almost always identifies an individual, and hence it constitutes personal data. For that reason, when our member countries have been sending their enforcement action information to the Secretariat, they are now bound by national legislation on data protection, as well as regional legislation on data protection, such as the GDPR, the General Data Protection Regulation of the European Union, or the Law Enforcement Directive, the LED, also of the European Union. We too at the Secretariat are also bound by our own data protection rules that have been set by the Secretary General. And this set of new rules at both the national, regional, and the OECD levels have resulted in the Secretariat for the Working Group on Bribery having to deal with a range of new issues that have come up and have been debated continuously for the last 2 years now. They range from the legal basis on which the Working Group and the Secretariat has the power to receive and process enforcement information, to issues such as the legal basis for our member countries to transfer their information to the Secretariat, which is then transferred on to a third country. And then there are also other issues like the security of that information when it is held at the Secretariat, as well as issues like retention period, how long we can keep the information before it has to be deleted. So as I said, these are issues that the working group has been grappling with for over 2 years now. We've gone through a number of stages. We finished revising the working group's mandate from council to deal with data protection issues, but now we're in the process of revising each of our internal work methodologies that involve the processing of personal data. So hopefully we will finish this work in the next few months, but certainly it's an area that you should be aware of if you want to expand your work on law enforcement information exchange. So with that, I'll end my presentation. We want to thank you for your time, and we'll be happy to take any questions that you have.